Okay, today is Monday, December 16. I'll make this short recording. I'm innocent. I should be working. There's no doubt about it. I'm innocent. And I don't know why I'm not working. And that's all I'm going to say is that I'm innocent. I should be working. Nobody's told me to this date why I'm not working. And I just don't get it. And anyway, Merry Christmas to everybody. And wish the best for everybody in life that has to offer. But again, I got to say I'm innocent. I don't know why I'm not working. So, it's really sad. It's really sad. I don't know why he falsified my documents. I don't know why. And accused me of doing it, and I don't understand why he did that, why I'm not working. I'm still claiming I'm innocent. 3 years now. You think they'd figure it out by now? Put me back to work. I don't understand. They didn't file a grievance within 10 days. I should be working. I don't know. Anyway, that's my statement for today. Monday, December 16, 2013. Merry Christmas. End of statement. Okay, today is Friday, December 20th, 2013. Making a short statement. This is Julio Zamora making a short statement for trial. It's just a reminder. The fact that, as we all know, they sent me home December 7, 2010. And I was on FMLA, and there's a third opinion. So there's no doubt I'm on FMLA, and they didn't pay my health and welfare. On December 15th, I had a notice of offer of work that became effective on December 15, 2010. They didn't honor it. Sometime in 2011, I guess it was 2011, but before that, there was a letter sent from the union attorney to myself or to my attorney notifying me that I was fired on December 16, 2010. I don't know how that could be. I was never notified. No registered mail, nothing within 10 days. Time limits. If it's not within 10 days, the employees return to work immediately. And we have 1,500 teamsters over there. If it's not within 10 days, the employees return to work immediately. The reason I mentioned that twice is because it didn't happen. And two, I was never notified of any grievance that was filed. I was never notified within the time limits. The grievance was made out on December 16th by Mike Sadler. He emailed it to the union and didn't notify the employee. Contract says you have to send registered mail, one to the employee, one to the company. Well, it didn't happen. He emailed it to the union, Local 439 Teamsters in Stockton, California. I should note that the union received it on December 17, 2010. Stamp received December 17, 2010. Mr. Nicelonger replied, all disciplinary action to be denied and the employee to be returned to work immediately. I'm assuming that wasn't within 10 days, but the fact is that he emailed it back to Safeway in Tracy, California. So the correspondence was kept between Safeway and the union, and the employee was never notified that any grievance was ever filed, period. So that's a violation of the contract. I was never notified that I was fired or a grievance was ever filed. Why they went on with a panel hearing, and in fact in the panel hearing they just put it in the biz and sent me home when I told them I was a severe profound hearing impairment and I have a legal document. Now, it wasn't until 2011 that I received the documents. At the panel hearing, they set it for 2011. Now, why they did that, I don't know. I don't even know what the panel hearing was about because I was never notified. I don't even know what the heck's going on. And I still don't get it. I don't know what's going on. I got nothing in writing. Nothing. So, Jesus Christ, man, I don't know why I'm sitting here waiting for a phone call, registered mail, report to work when they didn't file a grievance within 10 days. They didn't inform me, and the grievance was made out on the 16th. The union received it on December 17, 2010, and the incident was December 6, 2010. That's more than 10 days. That's 11 days. And worst of all, I wasn't even informed. I never received any registered mail. They didn't inform me of anything, and I've got the document that says it was emailed. So, I don't know what to think. I don't know what's going on. All I know is that I'm on FMLA. They didn't honor notice of offer of work. They didn't follow a contractual procedure. They violated the contract, Article 25 and 26 and all articles of the contract. They violated that. It's worse than that. They didn't even notify me. I didn't even know there was even a grievance filed until 2011. So I don't know what's going on. And I have a permanent disability. According to Q&E report, I can do my customary duties. So I don't know. And then I got the unemployment office twice. They took me off work, and they took me off work, and I got a letter from the unemployment office the first time for conflict of liability. And then they did it again on December 7, 2010. They just sent me home. And I had to file for unemployment, and I got another letter saying conflict of liability. I should be working. And if that doesn't beat all, I get a letter from my attorney to report to work. I report to work, and Mike Sadler says, no, I don't know anything about it. I go to the union, they go, I don't know anything about it. I don't know what's going on. I'm getting a runaround, I'm getting this and getting that, no grievance is filed within 10 days. The employee's not even notified. Jesus Christ, man, I don't know. I just got to remember to say this in court when I go to trial, mention it to the judge, and give him the documents, showing that the document was emailed. It wasn't registered mail. I was never notified that a discharge took place or a grievance was even taking place, period. I didn't have a meeting with the union until 2011, and that was on January 10th, I believe it was 2011, somewhere in January in 2011. I mean, that's more than 30 days. And then I don't even know what that was about. I'm just totally confused at that point. I don't even know because they didn't file a grievance within 10 days. So any documents or anything they send me before that, I don't even pay attention to it because they didn't file a grievance within 10 days. No void, final, and binding. They need to return me to work. And it didn't happen. I don't know what's going on. I'm totally confused. I don't know, I just, I don't get it. I should be working all this whole time. And they're paying me for sitting here, and I don't understand that either when I could be working. Contract says work first, grieve later, and they didn't do it. So I got to bring this up to Judge Bill, and I'm hoping that my attorney gets a copy of the documents I gave to the psychiatrist, and maybe he'll take a close look at it if I'm lucky, and we'll see what I'm talking about. I was never notified. That's the reason for this statement I need to remember for trial. I was never notified by registered mail. In fact, that they didn't send any registered mail. It was just kept between the union and Safeway, and the employee wasn't informed that a grievance even took place. I was never notified there was going to be a grievance until 2011, and then say it was a panel hearing. Now, I don't know how you can have a panel hearing if there's no grievance. I was never notified that a grievance was even taking place, or that I was fired, suspended, or discharged, or whatever. I wasn't notified of anything. So I don't know what this thing's all about. It's just totally confusing. I need the judge to make a decision on this, and I guess that's what the psychiatrist is saying. The judge needs to decide this case. So, and I am in complete agreement with that. A judge needs to decide this case, because I was on FMLA. I was on FMLA, and there's no disciplinary matter because there was no grievance filed in a timely manner. Not to me. I never received it. And they definitely didn't send any registered mail, because I got the document that showed they emailed it. So I don't know. It's mind-boggling, I just don't know what's going on. I'm just lost. Why am I not working? Jesus Christ, I'm going on 3 years with no paycheck and no medical coverage. And now I got job stress. God, anybody would have job stress after all of this. I mean, I just don't know why I'm not working. I just don't get it. I guess maybe the judge will have to explain it to me or explain it to them. But the attorney in court is going to need to explain why I'm not working. Going to have to explain something. I mean, because I got the documents that shows I was never notified. He's going to have to come up with something. I have a permanent disability and I can do my customary duties. So he's going to have to come up with something showing why I'm not working. Got to come up with something. I don't know what. I got the documents. I'm sure he probably has a copy. Or if my attorney let him know, I don't know. But they got to pay me all this back pay, and it's got to be at 14 hours a day, because they wouldn't let me clock out of that second time clock. So I just don't get it. I mean, why run 2 time clocks? I'm already on duty, and the machine is tamper-proof in the tractor, put in there by the federal government to be tamper-proof. I just don't get it. I mean, from false accusations to not filing a grievance, or letting the employee know that the grievance was even filed, or he was suspended or discharged or something. It's all wrong. It's all wrong. It's completely wrong. And why did the dispatcher falsify my logs to change the starting time? I don't know. He's not supposed to do that. It's a violation of Department of Transportation. And I don't know why he did that either. So, in the second time clock, why they didn't catch it by now, they should realize that second time clock has nothing to do with the clock in the tractor. We're on duty. When we log out of that tractor, we're leaving Tracy. That's it. We're off duty. I know they keep us on duty. We got to clock out of the second time clock with no time card, but it still doesn't matter. They're not paying us by that second time clock. I haven't been paid in the last 10 years for service rendered. And I don't know what that's about, but that's fine. Yeah, it's fine until he falsified my laws. And then it's not fine anymore. Then he needs to pay me. I mean, he shouldn't have falsified the laws. And I have a witness to the fact that the DOT said that it appears that they were tampered or altered with. So, and not only that, I have the logs. So, and I have the DOT regulation that states it's tamper-proof. So I don't know what's going on. I need to be put back to work as soon as possible. So I guess I have to wait for a trial date or wait for a phone call or registered mail or report to work. Either way, I'm going back to work. I need to go back to work in order to obtain my lifetime medical that I paid for ahead. So I need that lifetime medical, and the only way I can obtain it is if I go back to work and retire. So I need an automatic retirement date set by the court. That I'm guaranteed that 1 year no matter what, with automatic retirement. So I'm definitely going to need the protection of the court because they've taken me off the job twice. And twice I have a conflict of liability. So if they did it twice, they're probably going to try to do it the third time. So I need some protection so that I can retire at the end of 10 years with automatic retirement so I don't lose my lifetime medical plan that I needed. I have a permanent disability. So I need that lifetime medical plan, RSVP. So I don't know. I'm just gonna make sure I remember this when I go to trial and hope for the best. And it's like I said, Julio Zamora claimed double standards. Life is not fair. So I'm asking to be returned to work. So that's it. I gotta remember that when I go to trial. I don't know why they didn't put me back to work. I've got nothing in writing. I don't know what's going on. Now I got stress. I just don't get it. I don't get it. Okay, that's my statement for December 20th, 2013. I don't know why Nicewanger didn't have me put to work, but at least he sent a letter on December 17th, and I emailed it to terminal manager, Mr. James Williams. So he was informed to put me back to work immediately, and he didn't do it. So that's it. I guess that can't do any more than that. They tell me to go to work, and they don't do it. I guess they just don't do it. I don't know what's going on. No, I guess the judge will have to decide it. That's where it lays. I'm sure hoping I go to work before I go to trial. Jesus Christ. I hate to go into trial in that room and tell the judge, no, I'm still not working. Jesus Christ. I hope we don't come unglued. Okay, that's our statement. Friday, December 20th, 2013. And a statement. Okay, today is Friday, November 22nd. It's 1:05 p.m. As we all know, they sent me home and I was on FMLA. During the, I received the FMLA, I think December 12th. The FMLA leave began in October 2010 to 2011. Somewhere around there, but I was on FMLA when he just flat out sent me home. And the reason I'm bringing this up is the fact that, according to this article I'm reading, the third opinion is binding, pending receipt of either the second or third opinion. The employee will previously entitled to the benefits of FMLA. Upon request of the employee, the department will furnish the employee with copies of any additional medical opinion. The department will reimburse the employee for out-of-pocket travel expenses incurred to obtain second or third opinion. Okay, so we know that it's binding. The third opinion is binding and final. Okay, so that's the point I want to bring up. So I think it's important to know that. I'm sure the judge knows it. So the third opinion is binding. I'm on FMLA, and there's no doubt about it. So, and they didn't give me, the employee return to work will not be delayed by this contract, or by this contact. That's what it says. So, I guess they're in violation. So, that's it. I'm on FMLA. They flat out sent me home, nothing in writing, like I said before. And, they didn't pay my health and welfare, so I have no medical. And, it was a third opinion, so it's binding. So, and I informed a Disco Legal Clinic, so I guess they said there's nothing they can do. And the case is in workman's comp's jurisdiction, so there isn't anything I can do but sit and wait for a phone call or register mail or return to work until the judge decides this case. So, I guess I'm just stuck here and, waiting. I don't get it. Don't make any sense to sit here all this time and get paid for all that back pay. Because I'm supposed to work first and grieve later. They just didn't do it. They didn't do anything. So, that's it. That's a statement for trial. And I need to remember that. The fact that the third opinion is binding. So I am on FMLA legally. And they didn't give me any medical coverage when I left. They stopped paying health and welfare. So, that's it. I just got to remember this for Judge Court when I go to trial. Let it be noted. Okay, today is November 22nd at 4:29 in the morning. This is Julio, Zamora, 1385 El Camino Way, Los Banos, California. And it's Friday, November 22nd, 2013. Making this statement for Judge Will's court when I go to trial. I just come to the realization that I have no medical coverage. They sent me home on December 7, 2020. And they didn't pay my health and welfare. So I've been with no medical coverage for me or my family since December 7, 2010. And I have nothing in writing. I was supposed to work first, grieve later. No representation, no work. They just sent me home. They didn't give me nothing in writing. So I don't know. I don't want to repeat myself, which I'm doing. The point is, they sent me home on FMLA, no medical coverage, notice of offer of work that was effective on December 15, 2010. They didn't honor it. They received a letter from the union on December 17, I believe it was. They received a grievance on December 17, 2010. I should note that's more than 10 days. It's not within the time limits. Null and void, final and binding. There are no disciplinary issues. And they didn't produce any documents or records or anything else by December 25th, 2010. So they violated the contract and contractual procedures. So why am I sitting here and not working? I don't know, and I don't get it. I'm on FMLA. I guess I'm still on FMLA, and I guess they put me on leave. I didn't ask for it. They just sent me home. So that's my statement. I need to remember that when I go to trial. I have no medical coverage. I'm on FMLA, and I'm still on FMLA. And I guess that's it. I mean, Jesus Christ, there's a list of things. FMLA, severe profound hearing impairment, 132A, job stress. Jesus Christ, man. I mean, somebody ought to do something, you know. So anyway, that's my statement. Today is Friday, November 22nd at 4:31 in the morning. I need that 1 year, so I'm hoping the court puts me back to work for that 1 year no matter what. And I need my lifetime medical insurance that I paid for. And the company put money into it. I paid for, I don't know, a couple of years ahead. So I need my lifetime medical. In order to obtain it, I must return to work and retire from Safeway. So I need that 1 year with automatic retirement. So I'm asking the court for that. Be returned to work so I don't lose my lifetime medical insurance plan because, because basically I need it. I have disabilities and stuff, and my family needs it too. So, okay, that's my statement for Friday, November 22nd, 4:32 in the morning. I should know I made Modesto Legal Clinic aware of the fact that I have no medical coverage. I called them on November 21st. And they said there isn't anything they can do about that. And I'm not on disability and I'm not getting any money. And no medical coverage. So that's my statement for trial. Julio Zamora. Until then. Okay, today is Sunday, August 25th, 2013. I was just wondering, the fact that we have 2 time clocks and there's no time card or anything on the second time clock, and we're already on duty when we come to work, like I said before. Me and 400 other truck drivers, we're already on duty when we come to work. Okay, according to the Department of Transportation regulation and company policy and union contract, you will follow Department of Transportation. Now we have to clock in and out of that time clock, and there's no time card. And the automatic recording device or the recorder in the tractor is tamper-proof. Tamper-proof. There's no way you can alter or change anything on that log. The driver can't do that. He can't do anything. It's automated. Okay, so you can't falsify anything on that tractor, no matter what. You can come in at 10, 11, 12 o'clock. It doesn't matter. It's going to start at 10:30. And I don't understand what this is really all about. I can't figure it out. I don't have anything in writing explaining to me why I deserve any type of disciplinary action whatsoever because of that second time clock that has no time card. It doesn't record anything. It doesn't do anything. Okay? And as we all know, like I said before, the trip sheet, they only pay you by the miles. It doesn't record anything from the second time clock. So there's no way of knowing that you ever got paid or how much time you put in, other than the fact that it's going to be a mismatch on the trip sheet. Because when you log out of that tractor, you're off duty leaving Tracy. But it's a lie. It's not true. You're not leaving Tracy because you're still on duty because you're instructed to clock out of the second time clock in the driver's room. Now, that being said, I don't know what to think. I don't even know what's going on. I mean, they didn't give me nothing in writing. They explained to me why this or why that. I just follow instructions, just like 400 other teamsters and truck drivers there. We just do what we're told to do, and we do it. For them to take the time off the second time clock and alter or falsify my log and then not make me aware of the fact that that's what they did and write it down in the remarks section is wrong. Okay? It's completely wrong. It's not right. And I think they're just doing this because I have a disability. They didn't follow the time limits. They didn't notify me within 10 days, and I should have been put back to work like 1,500 other teamsters. And I don't know. I called Mike Sadler on the 10th day. I called him. I called him on the 16th. I have telephone records to establish the fact that I called Nightwalker on the 16th. And my wife was here, and there was other people here, because I want to verify the fact. I want to know what's going on so I can get back to work. But Nightwalker said he hasn't heard anything on the 16th. That's when Mike Sadler made out the grievance. On the 16th, that's the 10th day. It's got to be within 10 days. The union didn't receive it until the 17th of December, 2010. That's 11 days. I should have been put back to work like 1,500 other teamsters, but they didn't put me to work. And they didn't explain anything. They didn't give me anything in writing. And I've been trying to tell them for the last 3 years that they didn't file a grievance within 10 days. I going around and around and it just boggles the mind what the heck's going on. So I have to get this notation down correctly. I'm going to try for court. I go to trial. Because I need somebody to explain it to me. Maybe they have to explain it to me in trial. If that's what needs to be done, well, then it needs to be done. But I got to tell you, I got the document that shows that union received its stamp received the 17th of December 2010. That's 11 days from the date of incident. And the incident is December 6, 2010. Now, from December 6, 2010 to the 17th of April 2010 is 11 days. They didn't file a grievance within 10 days. And they didn't file within 10 days like they were required to do to provide documents, evidence, photos, etc. by the 26th of December 2010. So they violated step 1 and step 2 of the contract, So Article 25 and 26 is what it is. So, and all articles of the contract, they violated everything. But the point is, that second time clock doesn't do anything, and I don't even know what that's about, really. I can assume anything. I can assume that he's saying that I punched in late. I can assume that I was drunk. I can assume anything, but I didn't. I'm not going to. Because it's ridiculous. There's no time card. And me and 400 other drivers, we just do what we're told to do, and now he wants to use it for whatever, I don't know. See, I'm stumbling at words because I don't know what he wants, what he's doing. He didn't explain it to me. He didn't put it down. No representation, no nothing. I don't know what the hell's going on. And, Jesus Christ, man, somebody ought to do something. I mean, they ought to get testimony from the drivers. If it's not within 10 days, the driver's put back to work immediately. There's no doubt about it. That's the contract. So they didn't follow the contract. The second time clock, there's no time card, and the drivers and myself, for 400 plus drivers, and myself haven't been paid, and I haven't been paid in the last 10 years by that time clock, and we should be getting paid by the hour for services rendered. But we didn't get paid. We haven't been paid. Now, we follow the union contract. We follow company policy. I do what I'm told to do. We have a no false attendant policy that's been there for I don't know how long. And I don't get it. I don't get it. And, I'm not going to contact Mr. Nicelonger because my attorney sent me to report to work. Because Mr. and Mrs. Zamora of Safeway Private Insurance in Arizona
sent a letter to my attorney to report to work. So I report to work. And Mike Sadler says, I don't know anything about it. The union doesn't do anything. Mr. Nightwanger says he don't know anything about it. And I don't really recall if he said he was going to look into it or do this or do that. But I haven't heard anything. I'm still sitting here. So, I don't understand why Mr. Nightwanger didn't say something when I called him on the 10th day. He should have had me put back to work. Why he didn't put me back to work is the judge is going to have to ask the question. Why didn't Mr. Nightwanger put me back to work on the 10th day when I called? And I guess I'll have to produce the telephone records. But, I just don't know what's going on. So that's why I'm making this notation is the fact that I called Mr. Nightwanger on the 10th day. I have telephone records to establish that fact and witnesses, and the fact that he didn't put me back to work, or the company refused to put me back to work, one or the other. And the second time clock, those issues haven't been resolved by the union, and they laid it on workman's comp to resolve those issues. Disability issues, I suppose. I guess they might not deal with the second time clock. I don't know what authority they have. Maybe they don't have any authority at all. Maybe they're just going to deal with disability issues. And if that's the case, they still have to put me back to work. It doesn't matter. I have a permanent disability. I have a hearing impairment. I was on FMLA, and I wasn't fired on December 6th or December 7th. I was just flat out sent home, and I worked the whole year of 2010. And the QME report that goes along with the notice of offer of work states I can do my customary duties. So I should be working. And I'm supposed to work first and grieve later. That didn't happen. So why am I not working? I don't know. I don't know. I'm stumped. I really don't know why I'm not working. And there's no disciplinary matter at all. All issues are dropped because they didn't reply within 10 days. So there's no issues other than I have a disability. So it's obvious they're not putting me back to work because I have a disability. And that's the bottom line of this notation for court. The reason they're not putting me back to work is because I have a disability. And so I guess I'll have to wait till I go to trial and let the court make their decision. But the fact is, beyond a reasonable doubt, they didn't file a grievance within 10 days. Beyond a reasonable doubt, I called on the 10th day to Mr. Nightwanger, and he said he hasn't had anything or he didn't hear anything. Okay? That's fact 2. Fact 3 is that they didn't receive the grievance until December 17, 2010. And the incident was December 6, 2010, and that's the date that the dispatcher took the time from the second time clock and altered my time on my logs. And as I said before, I went to the Highway Patrol Office, Department of Transportation, and they said that it appears that my logs were tampered or altered with. So we don't need to go into that. According to 395.5, 395.16, and 395.8, according to that regulation, the dispatcher is the only one to enter the key, and he took that special privilege and he falsified my logs. Now, I don't know what more I can say to the fact that I need to be returned to work, and the notice of offer of work used to be enforced for 1 year, and that I should get all back pay from December 7th, 2010. And what about from 2002? I don't know, because there's no time card from December 7th, 2010. So the question arises, am I going to get paid from 2002 or December 7th, 2010? So I don't know how they're going to deal with that question or how they're going to act on it if they do at all. I know that they should pay me from December 7th, 2010, but there's no time card. There's no trip sheet. I didn't see anything. I didn't get anything. I got nothing in writing. So I should get all back pay and benefits and everything from 2002 or from December 7, 2010. So that's for the judge to decide. Now, I guess that's going to be my statement for the court. I don't know what else to do. I'm sitting here waiting for a telephone call or registered mail to report to work, and it hasn't happened. And I've been off work for 3 years, and I haven't had a paycheck in 3 years. I have not had a paycheck in 3 years, and I'm not on disability. I am not on disability. So, an insurance company hasn't sent me any money, and I don't know why they should, because I'm not on disability. But then again, I don't know workman comp rules and regulations. But before they sent me home, on December 7, 2010, I was collecting unemployment, and the unemployment office said they were in conflict of liability. And then I had to file when they sent me home on December 7, 2010, and the unemployment office states that they were in conflict of liability again, that I should be working. There's no doubt about it, I should be working. That's the state's position with the unemployment office. So, Christ, I don't know, I'm going on 3 years here, and I need my lifetime medical insurance, so I need to go back to work in order to obtain my lifetime medical that I paid for in 2002. So, I don't know what's going on. I have nothing in writing, nothing. It's bald minded. When I go to the psychiatrist, I'm going to present him with the documents showing that they did not file a grievance within 10 days. I'm going to give that to the psychiatrist. I'm also going to give the letter that I was sent to the attorney to me, and I don't know to my attorney or not, the letter that's stating that I was fired on December 16, 2010. I don't know how that could be if the grievance was made out on December 16, 2010. And that was the 10th day. That was the 10th day. They should have put me back to work. It says within 10 days. That's not within 10 days. So the attorney sends me a letter saying I'm fired on December 16, 2010. Mike Sadler makes a grievance out on December 16, 2010. The same day the attorney said I was fired, and the grievance was received by Local 439 on December 17, 2010. That's 11 days. It's not within 10 days. Now, I'm assuming that the union attorney made a mistake, but that's not for me to say. And so I guess I'll have to leave this up to the judge to decide what's going on here, because it's confusing, and they're not following the contract or contractual procedures. And Mr. Nightwanger should have sent them a letter for me to return to work when I talked to him on December 10, 2010. And he didn't do so, because I'm not working. I'm sitting here, and I don't know why. So, if Nightwanger is going to take any action about that, and the fact that they didn't finish the panel hearing, and due to the fact that I have a severe profound hearing impairment, and they didn't accommodate me, and I mentioned to him when I was there with a letter from the attorney to report to work the fact that I have a legal document. So I'm not clear about that, but I'm assuming that that's what I told him. But in any event, I had a letter from the attorney to report to work. He should have looked into it. He should have called my attorney and find out what's going on. If I have a legal document that I'm deaf and this and that, he should have talked to my attorney, Modesto Legal Clinic. But I don't know if he did or he didn't. In any event, it's not within 10 days. And I should be returned to work like 1,500 teamsters. And it wasn't done. And the second time clock is tamper-proof. You need a key in order to change anything on them laws. So the driver and the dispatcher didn't make me aware of anything on December 7th, 2010. So that has got nothing to do with my disability. It's just the fact that if he tries to say something, I don't know what he's talking about. He can tuck his head off all he wants like he did on December 7th, 2010. He was ecstatic. That guy was just, I don't know. I don't know what I walked into. I have no idea what this guy's yelling about, okay? There's no time card on that second time clock. And on the trip sheet, it only paid you with trip miles, and there's a mismatch. If you look at the trip sheet, you'll see where the driver logged out, and then there should be a second time on the bottom of that time, indicating when the guy clocked out of that driver's room. In the driver's room, he clocked out. Now he should be getting paid by the hour. He should be getting paid by the hour because he's not getting paid by the trip sheet because they only pay by the mile. So the difference between the time the driver logs out of that truck and the time that's written in or printed in underneath it when he clocked out of that driver's room should be paid by the hour because there's no proof that he ever got paid because the logs are not recording anything. They're not recording nothing when he logged out of that truck. It says leaving Tracy. It's a lie. The driver's not leaving Tracy. It's a violation of Department of Transportation regulation. And I don't know why nobody's looking at it. Mr. Nicewonger should check it out. But the workers' comp don't handle union issues. They only work with disability issues. And I have an issue with disability, and the union admits that. So they laid it on workers' comp to put me back to work. And I hope workers' comp puts me back to work because we have a contractual agreement that if it's not within 10 days, I'm to be put back to work like 1,500 other teamsters. And the workers' comp judge should follow the contractual procedures and put me back to work. And then the hearing impairment violation of 132A, I don't know what he wants to do about that. But I'm asking the judge to put me back to work because I was on FMLA. They violated the 10-day time limit. They didn't produce anything on the December 25th or 26th, 2010. No evidence, photos, or documents stating what my disciplinary matter is or should be or was. So it's null and void, final and binding. All issues are dropped. There are no issues other than the disability and the fact that they didn't follow contractual procedure. They didn't file a grievance within 10 days. So that's my notation for trial. And I'm gonna. I invoke double standards. I invoke double standards. Life is not fair. And I'm asking that the court should take that into consideration and return me to work according to the contract and according to workman's comp rules and regulations. That's my statement for trial.
I'd like to know one thing. I'd like to make a correction on that last recording. Instead of trip sheet, it should say logs. Logs. When everything has to be recorded, you get paid by the logs. You only get paid trip miles. Now, when you log out of that truck, it says leaving Tracy. On the left side of that log down below, there'll be a different time. The time will be from the time clock in the driver's room. There's a mismatch. That time when it says leaving Tracy to the time that you log out of that driver's room should be paid by the hour. Should be paid by the hour, and there's no time card. You should get paid for services rendered, and it's not being done. So I like to make that correction. And two, it's like I said, it was time limits. They violated time limits. They should have been returned to work. And that's the bottom line. All issues are dropped. I should be working no matter what. The State Department of the Unemployment Office, they said they're in conflict of liability. I should also be working. And also, when Mr. Nicewonger sent the letter on December 17, 2010, to James Williams, the transportation manager, to put me back to work immediately, and he didn't do so. I'm going to give a copy of that to the psychiatrist to back up what I'm saying. Okay, so I should be working all this time because they're in contractual violation, and they didn't put me back to work at least 3 or 4 times when they were told to do so, including administrative judge while Judge Bill was off sick. So why I'm sitting here waiting for a phone call and registered mail, I have no idea. This is mind-boggling. I don't know what's going on. So when I get to the psychiatrist, I'll produce all documents. And like I said before, I, Julio, Zamora, invoke double standards. Life is not fair.
Okay, I'm just going to add this to the end of that recording. I'd like to remind the court the fact that when I was sent home on December 7, 2010, when I received the QME report on December 1st, 2010, it wasn't complete. The QME report was not complete because the doctor, I forgot his name, said that he doesn't do hearing tests. And I received that on December 1st, 2010. Like I said, short story. I don't want to make a long story out of a short story. The fact is that the QME report wasn't complete. They offered me work for 1 year, and they needed it enforced. Because the QME report wasn't finished yet. They just flat out sent me home. And I'm sitting here, and I don't know why I'm sitting here. They violated all the time limits. They didn't produce any evidence of what my disciplinary action is to be or what it was by December 25th, and at least they had to put something in by December 28th, within 10 days. They didn't do so. They didn't do anything. They went around the Board of Adjustment, and that has time limits within 30 days. They didn't do that. They just didn't do anything within the time limits. And I don't know why I'm sitting here waiting for a phone call or register mail to report to work when I have 200 employees underneath me. Now, James Williams, the transportation manager in Tracy, California, knows all this. He should have returned me to work like he does for 1,500 other teamsters or 400 truck drivers. If it's not within the time limits, they're returned to work immediately. If it's not within the time limits, they're returned to work immediately. Now, I should note for the record in Administrative Judge Bill the fact that I don't know why I'm sitting here. They didn't produce anything. I never received any registered mail whatsoever of any suspension or discharge within the time limit. I did not receive one document of why I'm sitting here waiting for a phone call or registered mail to report to work according to the notice of offer of work that I asked for Eureka Run at 10 o'clock in the morning. And I'm still sitting here waiting. So I should get all that back pay because they didn't comply. 3 times they didn't comply. And I hate to keep repeating myself, but my life is on the line here. And I don't know why I'm sitting here. I don't have one document. Not one document for suspension or discharge, or the reason why I'm sitting here by registered mail within the time limits. Not one. And I'm still sitting here. So I should get all that back pay and benefits, and I hope Administrative Judge Grill returns me work according to the notice of offer of work that wasn't complete. They just flat out sent me home. And so I'm not going to go into it anymore about the deposition that I wasn't accommodated or anything else, and I need to take another deposition for the record. And that I have a new attorney, Mental Legal Clinic, who took my case. Obviously, by my statement, you know why. The fact that Judge Bill didn't have nothing on the table not my severe profound hearing impairment or the notice of offer of work. And that, if it's at all possible, if Judge Grill could agree to the fact that Safeway should pay all attorney fees and expenses to Modesto's legal clinic for all their hard work and getting me to be returned to work. For the fact that Adam Stewart, I feel that he failed in his responsibility by not giving me a hearing test or not mentioning the fact to the Administrative Judge Bill that the QME report was not complete and I didn't get paid every week or every 2 weeks, and that they're in conflict of liability with the EDD, Department of Unemployment, and he didn't mention one word about it since 4/17/2009 and ongoing, and I received another document from EDD saying that Safeway is in conflict of liability. I should be working. So with that being said, and the fact that Safeway doesn't want to comply, and it's just more time and money for Modesto Legal Clinic, who's representing me. And I don't feel I should have to pay Adam Stewart anything. So, but that's for you to decide what is fair and equal under the law. And your decision, I agree to accept your decision, whatever is reasonable under the law. But I do request to go to trial, to hear the case for the Two Disability Act of 2009. Anyways, like I said, I have permission, or I was instructed to pursue this by the union attorney on workman's comp, and they're aware that I have a disability issues. I exhausted the union remedy. There is no remedy under the union to return me to work because I have a disability. And so they're not going to deal with it, and they threw it on workman's comp's lap. So, and the fact that I told them that I had a severe profound hearing impairment, and that wasn't acceptable, even though I sent them a prescription, and the test results to the union attorney, and it wasn't accepted, and they denied me arbitration. And so I, Julio Zamora, invoke double standards. Life is not fair. Okay, today is Friday, March 1st. Making a statement for Judge Grill Settlement Conference in Stockton, California. On 3/21/2009, I was injured on the job, and I went to see Nancy Ferdillo. And she stated that it was a sprain. I don't recall going to the hospital or an MRI being taken at that time. She's an alcohol and drug technician, which gives you tests to see if you were on drugs or alcohol at the time of injury. And there was no doctor present. Maybe a week or 2 weeks later, I ended up in the Los Angeles Memorial Hospital with severe pain. It was really, really bad. I couldn't take it anymore. So I was there all night long, and they took an MRI and discovered the fact that I had a pinched nerve. They took an MRI the next day. I went in there for left leg pain, the same thing I'd seen Nancy Ferdillo for in Tracy, California. Drug and alcohol technician said it was a sprain. Now, I'm not going to go into the PR2 report because it's incorrect and it wasn't completely signed properly. And the fact is I had a treating physician that I signed for good for 1 year, Perolosi, chiropractor. That if I get hurt on the job, that I'm to go to the company doctor for 30 days and then the chiropractor is to take over. Okay, so, and the Los Angeles Memorial Hospital made out an occupational report stating the fact that I went in there for left leg pain and that I have a low back, a pinched nerve. and I don't remember who I got the referral from. If it was Banner Memorial Hospital, what doctor it was, or if it was Dr. Yip or Perlosi, but they gave me a referral to Dr. Baby, and the fix to pinch nerve is a walk in and walk out type deal, and I was denied by Safeway, and they sent the letter to the wrong person, to Dr. Hubby, asking her if it was job related, the pinched nerve, and they should have sent it to Nancy Perdillo, the drug and alcohol technician, but they didn't do so, because she's the one that said it was the sprain. So, okay, I haven't been paid every week or every 2 weeks, disability payments. Since, I would say since 3/21/2009 or 4/17/2009. I had to file for unemployment, and they sent me a letter stating that Safeway was in conflict of liability, and they sent me another one in 2012 or 2013 that Safeway is in conflict of liability. I should note that I have a notice of offer of work that I received on December 1st. December 3rd, I went to work. On December 7th, 2010, they flat out sent me home. Just flat out sent me home. I had no representation. And the fact is, I was supposed to work first and be later. That didn't happen. They just flat out sent me home. And they made false accusations. And this is all disability related to the fact that I filed in 2009 severe and profound hearing impairment from reefer noise. I come to find out at the settlement conference, Judge Bill's court suggested that I get a legal document for severe and profound hearing impairment, and come to find out that I've had a hearing problem since 2006. I needed to accommodate with a listening device because I have a more than a 50% hearing loss in both ears. And I should note also for the record, since 2006, I have never been accommodated with any sort of listening device or hearing aids or anything else for that matter. It wasn't taken serious by the union or the company. But due to the fact that they had a panel hearing, they flat out sent me home when I mentioned the fact that I had a severe profound hearing impairment, and I asked the job steward, are you an authority on severe profound hearing impairment? And Mr. Nicelonger, the DA from Local 439 Teamsters in Stockton, California, which is a union shop, was there also, plus another shop steward was there when I made that statement. And he said he's going to look into it, and they just flat out sent me home and didn't accommodate me. And I should also note the fact that Safeway didn't follow contractual procedures. I was denied to return to work because they didn't comply with the time limits, like they do for 1,500 other teachers. I returned to work immediately if they violate the time limits. They didn't do so. I should also note that they're required to go to Board of Adjustments for all suspension and discharges within 30 days. I should note that on December 17, 2010, Mr. Nicelonger sent a letter to the terminal manager, James Williams, that all disciplinary action to be denied, and to send all proof, photos, evidence, whatever you have by December 25th, to establish the fact beyond a reasonable doubt that Mr. Zamora did wrong, or deserved disciplinary action, and to set a time and date. Well, the terminal manager, James Williams, did not comply. He set a date for January 11, 2011. I should note that's not within 30 days. According to the contract, all Board of Adjustment suspension and discharges are to be heard within 30 days of date of incident. And they didn't comply with time limits or anything else for the record. And on top of that, I was never notified that I was ever discharged by registered mail. I was never notified that I was ever fired, discharged, or suspended by registered mail, according to time limits. Okay? And so going from there, they didn't honor the notice of offer of work. They didn't apply, even though they made an agreement with Workman's Comp to Workman for 1 year. and it was deemed accepted, whether I turned it in or not, and I had 20 days to comply or think it over if I wanted to change the job or retire, etc., etc. Well, I asked for Eureka Run 10 o'clock in the morning bid, and that I was hired in 2002, and that I had 200 employees underneath me, and there was work available, and that anybody who works underneath me, I get paid for that day, and it's a 24-hour operation, 24 hours a day, and there's 400 truck drivers there. And I should note that I've been waiting for a phone call or registered mail to return to work, in which they are not complying with the notice of offer of work, and they're not completing their agreement that they made. In other words, they're in violation of their own agreement. So I needed to be enforced by Judge Grill in the settlement conference. I'm waiting for a court date from the Modesto Legal Clinic because we were waiting for a document to get a legal document stating that I have a severe and profound hearing impairment, which states that I had a hearing problem since 2006. And they haven't accommodated me with any listening device or whatsoever since 2006. Okay? So on December 7, 2010, they just flat out sent me home and they didn't pay me for the day. And I wasn't represented by the union on interrogation by the dispatcher. He told me that Chuck Stewart is on his way and he told me to sit down. And I was supposed to work first and grieve later, it didn't happen. And they just flat out sent me home, again, I need to repeat myself, but I have a severe profound hearing impairment. The panel hearing was put in abyss, and I told them, are you an authority on severe profound hearing impairment? And they just flat out sent me home. I had a settlement conference, and Judge Bill was off that day, and Adam Stewart was my attorney, workman comp attorney at the time. The administrative judge suggested that they put me back to work due to the fact that the Safeway attorney was on the phone with Safeway, and Adam Stewart approached me, and my wife was there and asked me how long I could work for. And I thought that was peculiar because I had a notice of offer of work guaranteed or work for 1 year, which they didn't comply to. So that was the second time. The first time they violated the time limits in the contract, and they didn't put me back to work like they did for 1,500 other teamsters. The second time was the administrative judge suggesting that they put me to work, and the Safeway attorney must have told Adam Stewart, I don't know, because when he asked me how long I could work for, and he left, a lady or a secretary came up to us and told us to go to the lunchroom, and then later told us to go home. So that was the second time. The third time, Mr. and Mrs. MORLES, Safeway Private Insurance from Arizona, sent me a letter, or sent my attorney a letter, honoring the notice of offer of work, suggesting that I should sign it and send it to Arizona, which I did registered mail in 2013. My attorney, Modesto Legal Clinic, sent me a letter to report to work immediately. I did so. Safeway and the union did not comply, or the union didn't take any action, even though that they were aware of, or I made them aware of, that I had a severe profound hearing impairment to their attorney, and I also sent them a copy of a document of an examination showing and stating with a prescription that I had a severe profound hearing impairment, and they ignored it. In fact, I asked for arbitration, and the union attorney denied it, but suggested or mentioned the fact that we know you have a disability issue, and that arbitration is refused, and they could pursue it under workers' comp if you wish to do so. At that point, I figured I exhausted the union system, whatever it is. I exhausted it, and now it's in workman's comp flat. So at that point, they didn't comply. They put it on workman's comp comply, so I'm asking workman's comp to enforce the notice of offer of work, and I'm asking for trial. because I'm assuming the fact that they're in violation of 2009 Discrimination Act against the severe profound hearing impairment of people with hearing impairment, and that the union did not comply with federal law. So I could be wrong or I could be right, I don't know. So, but I'm asking to go to trial so that the judge can make a decision on that, for the fact that I've been sitting at home waiting for a phone call or registered mail to report to work since December 7, 2010, and I need a court order to get all back pay and benefits 7 days a week, 14 hours a day, plus my lifetime medical to be restored, medical, prescription drugs, Delta dental, eyeglasses, and I don't know about hearing impairment, and then I'm at 90%, so I don't know what the court wants to do about that, but I'm asking for it to be reinstated. And the fact is, I'd like to make a notation for trial. Add this notation to the recording I just made. And today is Monday, April 22nd, 2013. Just add this recording to the notation I just made, for the fact that I should never lose my lifetime medical that I paid for the last 10 years. And the fact that I should have some protection from the court, that whether they retaliate on me or they send me home or quit or fired, whatever, I should have some protection from the court, that I don't lose my lifetime medical for life with no premium. I don't pay any premium when I retire. So that should be protected, no matter what happens in the future, that I don't lose my lifetime medical that I'm covered under health and welfare for life. Whether I'm working or not, it shouldn't be stopped no matter what, okay? Because I have a disability and I have a hearing impairment, and I pay for that. That's a lifetime medical plan. I should have some protection from the court. So I hope the court can decide on that lifetime medical plan, that they're not allowed to take that away from me no matter what, whether I'm fired or sent home or I quit or no matter what. My lifetime medical plan is to continue on without a break in service. So I'm asking for that. If the court can make a decision on that, I would appreciate it, due to the fact it's a union shop and that they discriminate against me, the union. So I don't know why they didn't accommodate me or anything else, because I lost my lifetime medical. It's wrong. I'm asking for some protection and no breaking coverage if I should be sent home, or they retaliate, or I quit, whatever. No break in lifetime medical plan. That it should be continued on for life because I have a permanent disability. That's my notation to be added to the last recording. And I should note that I, Julio Zamora, invoke double standards. Life is not fair. Due to the fact that all disciplinary action was denied on December 17, 2010, because the grievance was received by Teamster Local 439, Mr. Nightwalker, on December 17. It was stamped received Local 439 on December 17, 2010. That's more than 10 days. And I should note they didn't respond in 10 days on December 25th, 2010, when they were required to do so according to contractual procedures, and they violated the time limits and also step 1 and step 2 of the contract. And I should also like to note, for the record, that the fact that any documents or any evidence or statements that's not received by December 26, 2010, not to be valid and not to be accepted by the court, due to the fact that they didn't follow contractual procedure or time limits. Due to the fact that they didn't follow contractual procedure or time limits. They didn't produce anything by December 26, 2010. And all issues are dropped. Null and void, final and binding. There are no issues after December 26, 2010. and which they didn't comply, and the union didn't enforce contractual procedures, let alone a hearing device, or assisted hearing device at the panel hearing, and he put it in a bit and sent me home. So I'm asking to go to trial for the court to get a court order for back pay and benefits and automatic retirement on my birthday on September 7, 2013. And that everything to be restored, back pay and benefits and pension and RSVP. I don't make any payments as the premium, lifetime medical. I need that reinstated, and I don't make no premium payments after I retire. None. And I need that reinstated or made whole again, including my pension, my back pay, and health and welfare to be paid. Because my wife is sick and she ended up in the hospital, and it's really hard. I have to pay for that bill. So if they could pay for the health and welfare for the year of 2013, I would appreciate it, and then I wouldn't have to make payments to the hospital. And the union put it on workman's comp to resolve these issues. They said I could pursue it under workman's comp, so that's why I'm bringing all that up in the union matter. I'm bringing it up for the fact that they didn't deal with the issues of severe profound hearing impairment, and the fact they didn't deal with the issue, the fact that the dispatcher on December 6, 2010 changed the time on my log from 10:30 to 11:15, taking the time from the second time clock. I should note that it put me in violation of the Department of Transportation and company policy. And he accused me on December 7, 2010 of falsifying documents or intent to falsify documents that he altered or falsified on December 6, 2010. And I should also note that the onboard automatic recording device in the tractor is tamper-proof. And you also have to have a key in order to change anything. And the dispatcher is the only one with the key. I'm assuming that's correct because I've seen them change the time on logs before. And I'd like to note also that we get paid by the trip sheet. The trip sheet that belongs to the tractor that prints out logs. I should note that they don't pay delay, they just pay trip miles. Sometimes they pay delay, sometimes they don't. So my point being is the fact that when we log out of that truck, we're off duty. Now, if we log out of that truck, we're off duty, and we're required to clock out in the driver's room and clock in. Why, I don't know, when we're already on duty. The fact is, it's not being recorded, and we're not getting paid by that second time clock. I haven't been paid in the last 10 years myself or 400 other truck drivers. I should know that the time clock in the driver's room, we're required to clock out. When we log out of that truck, we're still on duty according to company policy or instructed to do so, myself and 400 other truck drivers. When we're logged out of that tractor, we're not allowed to go home. We have to clock out of and check in the driver's room and clock out, and there's no time card. We don't get paid by the hour when we should be getting paid by the hour for services rendered, but we're not. And I was sent home on December 7, 2010, and I didn't get paid for that day, and there's no time card. In fact, there's not even a trip sheet for that day. What happened to it, where it went, I don't know. But in any event, I should get all back pay. There's no doubt about it. Okay, and the dispatcher is guilty beyond a reasonable doubt because he altered my logs by taking the time off the second time clock and changing the time on my logs, which is not required to do so or has the authority to do so according to the Department of Transportation Regulation 395.15, 395.16, and 395.8. He's not allowed to alter or change anything on non-logs. And if he is, he's supposed to make the driver aware that he did so. And he didn't make me aware on December 7, 2010 what he did on December 6, 2010. And again, I was not fired on December 6, 2010 or December 7, 2010, for the record, or corrected, and whatever the case is. I don't know what authority they have on changing law. Under the Department of Transportation 395.15, 395.16, and the interpretation in 395.8, it states in there that they're not allowed to alter or change anything on them laws. If there's a problem, there's right in the remark section what the problem is. And what the problem is, and make the driver aware. They didn't do so on December 7, 2010. And so I should note for the record that they didn't honor the notice of offer of work at least 3 times. They denied to put me back to work. And that I have a permanent disability according to the QME report. And it states in there that I can do my customary duties on my job. And I should also note that according to the legal document that I have that was requested by Judge Quill in the settlement conference to a 2 attorneys that I just received, that I have a severe profound hearing impairment since 2006, and that I did read. I'm not good at it yet, but I'm learning, and I'm also trying to learn sign language. But the point is, I've never been accommodated at any time since 2006, and they need to accommodate me with hearing aids. But I bought my own, and they're old, and they don't work at all. And I need something that doesn't that blocks out background noise and stuff like that from the reaper. So again, I'm asking for a court order to be returned to work, all back pay and benefits, and health and welfare, and my lifetime medical, according to the 2009 Disability Act, and also to the contract, okay? Because I didn't do nothing wrong on December 7, 2010. The only thing I received was a notice of offer of work, and they just flat out sent me home, and I was also on FMLA. So this is my request for trial, for Judge Quill to consider sending this case to trial to resolve the issues of the Disability Act of 2009, hearing impairment. I would appreciate it if we did that, and I also would appreciate the fact that he enforced the notice of offer of work and returned me to work according to the contract. And I would appreciate that. And I should point out that the fact is that they've been refusing me, denying me medical treatment. I don't get paid every week or every 2 weeks in 3/21/2009 or 4/17/2009. They refuse me to put me back to work when I have a full duty release to go to work. They won't accommodate me with hearing aids. They won't honor the notice of offer of work. I hate to keep repeating myself, but I do have a severe profound hearing impairment, and my life is on the line. And I need the notice of offer of work to be enforced for the fact that my daughter needs 1 more year at the university to get her BA in biology. 1 more year. I need that 1 more year. And they made an agreement where Workman's Comp to work me that 1 year. And I'm asking for it to be enforced so that my daughter can go to university. And that was a guarantee for 1 year. And I didn't start 1 day on the 10 o'clock shift Eureka run. So I'm asking Judge Bill to consider that. And I'm also asking him to consider the fact that a double standard is the application of different sets of principles for a familiar situation, or 2 different people in the same situation. A double standard may take the form of an instance in which certain concepts often, for example, a word, phrase, social norm, or rule, are perceived as acceptable to be applied by one group of people, but are considered unacceptable, taboo, when applied by another group. The concept of double standard has long been applied as early as 1872 to different moral structures on men versus women. A double standard, thus, can be described as a sort of biased, morally unfair suspension towards a certain group, of the principle that all are equal in their freedom. Such double standards are seen as unjustified because they violated basic maxims of modern legal jurisprudence that all parties should stand equal before the law. Double standards also violate the principle of justice, known as impartiality, which is based on the assumption that the same standard should be applied to all people without regard to subjective, bias, or favoritism based on social class, rank, ethnicity, gender, religion, sexual orientation, age, or other distinctions. A double standard violates this principle by holding different people accountable according to different standards. The phrase "life is not fair" may be invoked in order to mollify concerns over double standards. I'm hoping that Judge Bill considers this statement for the fact that if the company doesn't comply with the time limits under the contract, 1,500 teamsters are returned to work immediately. Well, it didn't put me back to work. And James Williams, our transportation manager, he knows everything. He knows what's going on. But he didn't comply. He didn't put me to work, back to work like they do for 1,500 teamsters or 400 truck drivers. I should note that for the record. And I should also note for the record that they didn't accommodate me with any lifting device whatsoever since 2006. So I'm asking Judge Bill to consider this and to enforce a notice of offer of work because my life is on the line here and I have no lifetime medical, I have no medical coverage whatsoever. Even though I paid for it in 2002. I paid $3,000 plus to cover for 5 years so that I can retire at any time. And I should also note that the fact that Safeway called their health and welfare and said I didn't work at Safeway. And that barred me from getting any kind of lifetime medical or asking them to keep me covered. That didn't happen. So, and the fact that the dispatcher who falsified my logs by taking the time off the second time clock, and they have a no-fault attendance policy, and they applied it to everybody else, but they didn't apply it to me. No-fault attendance policy that's been as part of the company policy for 10 years that I've been there, and from my understanding, it's been on there for at least 20 years. No-fault attendance policy. So, and the fact that I never received any registered mail or anything else stating that I didn't work at Safeway at any time, not within the time limits. Okay? So, and the fact that they just flat out sent me home, and they didn't pay me on December 7th, 2010, time card or my trip sheet or whatever it is, and dispose of it. I don't know where it went, it disappeared, and I never got paid for that day. So that's why I'm asking for back pay from December 7, 2010. And I hope Judge Bill considers again to enforce a notice of offer of work and then to send this case to trial. And I hope he considers this seriously for the fact that I have a hearing impairment and that the union should be held responsible under the Disability Act of 2009. And that's my statement for the court. So I hope Judge Bill considers the double standards.
I should like to note one thing, that I stand to be corrected by my statements and everything, due to the fact that I have a notice of offer of work that I received on December 1st, 2010. Mike Sadler and James Williams are well aware of the fact that I have a notice of offer of work that I'm guaranteed for 1 year, and they refuse to comply. And I'm sitting here waiting for a phone call or registered mail to report to work, and they refuse to do so. And I should also like to note for the record that any statements or documents that's not handed in before December 26, 2010 should not be accepted by the court. Because anything not sent in by December 26, 2010 okay, is null and void, final and binding, and all issues are dropped. And James Williams and Mike Sadler of the Safety Department and James Williams of the Transportation Department, the manager, knows all this. But it doesn't matter. They refuse to put me to work. They refuse to comply with contractual procedure or workman's comp rules and regulations. Now again, I repeat myself, I stand to be corrected, but I'm asking the judge not to accept any document that's not dated before December 26, 2010. And I hope he considers double standards. I, Julio Zamora, invoke double standards. Life is not fair.